The Supreme Court's conservative majority signaled skepticism Monday over the use of race-conscious admissions at American colleges. In one of the most controversial cases before the court this year, questioning the boundaries of such policies and whether they are actually needed to ensure diversity. At issue are policies at Harvard College and the University of North Carolina that permit admissions offices to weigh the race of applicants as one of many factors that help decide who will be accepted. Depending on the scope of the court's ruling, the outcome could have profound implications beyond higher education, spilling over into workplace diversity programs and other efforts to confront discrimination. Several of the court's conservatives noted that the 19-year-old precedent that permits the use of race in admissions had warned that such policies shouldn't be needed forever. How, the court's conservative justices asked, will supporters of the policies determine whether the goals of affirmative action had ever been reached? I don't see how you can say that the program will ever end, said Chief Justice John Roberts. Associate Justice Brett Kavanaugh noted the 2003 opinion at issue in the case noted a timeline of 25 years for ending race-conscious admissions, though the sides have debated the significance of that suggestion. Are you saying when you're up here and it's 2040, are you still defending it? Associate Justice Amy Coney Barrett said. Like this is just indefinite? Associate Justice Clarence Thomas, who has opposed race-conscious admissions in the past, pressed the attorney representing North Carolina for a definition of diversity and its benefits. I've heard the word diversity quite a few times and I don't have a clue what it means, Thomas said. It seems to mean everything for everyone. Ryan Park, arguing on behalf of UNC, said that diversity reduces groupthink and leads to a more efficient outcome in seeking truth. I guess I don't put much stock in that, Thomas said, because I've heard similar arguments in favor of segregation. The court's liberal justices, meanwhile, defended the need for race-conscious policies. I thought that part of what it meant to be an American and to believe in American pluralism is that, actually, our institutions are reflective of who we are as a people, Associate Justice Elena Kagan said. Associate Justice Samuel Alito, a conservative who has opposed race-conscious admissions policies in the past, offered a hypothetical where an immigrant from an African country moves to a rural and mostly white part of North Carolina and describes, in an admissions essay, how he or she had to confront a different culture. Wouldn't that be permissible? Alito asked. Patrick Strawbridge, representing the Anti-Affirmative Action Group, said it probably would be permitted. Because the preference in that case is not being based upon the race, but upon the cultural experiences, Strawbridge said. That prompted a quick response from Kagan. Race is part of the culture and the culture is part of the race, isn't it? Kagan said. I mean, isn't that slicing the bologna awfully thin? Years in the making, the Harvard and UNC litigation arrives at the Supreme Court as the nation continues to wrestle with the fallout from the decision in June to overturn Roe v. Wade and end the constitutional right to abortion. The two cases are among several this term that require the court's 6-3 conservative majority to confront the fraught issue of race in America, as well as questions about the extent to which the government may consider race to remedy discrimination.